House Bill 1661, which is relative to conversion therapy, seeking to change a person's sexual orientation. I am Representative Schmidt. I am chair of the Committee of Conference. Across the room from me, we have Representative MacKay, we have Representative Gordon, and we have Representative Kotowski representing the House. To my immediate left, we have Senator Daniel Pierce and Senator Prescott, who will hopefully be on his way here. Okay. Does anybody need a side-by-side?
I'll take it.
I want you to be happy.
Do you need one?
Get my scribbling around. Welcome. Thank you. You can see Senator Prescott has arrived, so we have a full house. Okay, Senators, what we have here is a slightly different version of 1661. Came out of the Senate as came out of the House, which was passed. So in the interest of saving time, who would like to discuss the changes?
From the Senate.
From the Senate.
Version? I can do that. Or you can do that.
I can do that as well.
Okay.
Yeah. We narrowed down a lot of the House version to show the definition of conversion therapy only, and then put in safeguards for constitutional rights. The discussions with the Senate have always been, we want to make sure that we do the right thing by having a statement on conversion therapy and making sure that it is no longer going to be practiced. However, we want to make sure that there were strong safeguards for parental rights and our First Amendment rights. And I believe that we've met that balance coming to that position by narrowing the focus of the bill to just the definition and the prohibition, and then the definition of our rights. And looking at that 1661 as amended, on page 1, line 28 and down. So who is any licensed professional, as listed in paragraph 1, who proposes to engage or engages in conversion therapy on a patient under 18 years of age shall be considered to have engaged in unprofessional conduct, shall be subject to such discipline as the relevant licensing authority deems appropriate. This language allows each licensing authority to take the appropriate action is within their discipline. So if there's any work to be done, I would think that this might be an area where the Senate could look at that and say, we want to subject to rules provision there. We might be amenable to something like that, so that there is, rather than just this line describing what would occur as unprofessional conduct, what would be the discipline that would occur. We have one line. If this is something that the House would like to work on, I would be amenable to that. I believe the Senate would be amenable to that. But remember, the Senate came forward with a floor amendment for establishing a commission. That was turned down. The Senate came forward with a first attempt on my part to narrow the focus and expressing religious freedoms and pastoral counseling and parent-child relationship protections. And that one went down. That failed. We moved forward with the final amendment that was passed. Both Senator Pierce and I are on the amendment. And if you look at line 28 of page 1, it's a significant change in paragraph 2 here of L:2. Any licensed professional as listed in paragraph 1 who proposes to engage or engages in conversion therapy was a very important part of the compromise to get people to coalesce and pass this amendment. And I believe that Senator Pierce, you may want to expound upon that.
Sure. The House bill that came across to the Senate had provisions to be added into the Consumer Protection Act, and also prohibitions against advertising and consequences of advertising for engaging in conversion
Could
therapy.
I ask you to speak up a little louder?
Okay.
Start over again.
So the House version, as it came to us, had provisions that would have added the practice of conversion therapy into the Unfair or Deceptive Trade Practices Act. And also had prohibitions against advertising for engaging in that. The Senate took those out and, as a compromise in its place, added what Senator Prescott just said. We added the words proposes to engage, such that if a licensee solicits clients for conversion therapy, he or she is going to be subject to discipline. And it was the Senate's determination that that was enough of a deterrent to the advertising or the things that would be deemed, that the House deemed to be under the Consumer Protection Act, that was enough of a deterrent for a licensee, that was all that was needed. And again, that was a compromise that we reached. Because I think the Senate's focus wanted to be solely on the licensees, those whom we regulate.
Representative Kotowski, you have a question?
Probably for Senator Pierce. Senator, who would be the entity that would, if you will, come down on someone who did this or proposed to do these kinds of things? Would it be the licensing agency? Would it be the courts? Would it be, who would do that?
It'd be the licensing boards, as it says, shall be subject to such discipline as the relevant licensing authority deems appropriate.
As they seem appropriate.
Yeah, and that's language straight out of the House bill. We did not amend that part of the House bill. And so when you look in 332L2, Roman 1, and you see that list of statutes there, each of those statutes refers to a specific profession. And each of those professions, of course, is regulated by its own licensing board. So the licensing board, it says relevant licensing authority in Roman 2. It's referring back to those boards in Roman 1.
Questions?
Senator, can you tell me on line 22 on page 1 under RSA 330A16, who is being regulated?
No, I don't have those sections memorized. I have statutes over here.
Would it surprise you to know that that section had been repealed?
I don't know. I can go with the books if you like.
I've already checked. It's more of a statement.
Okay.
A follow-up?
Sure.
Going further on the line, can you explain to me what RSA-A-:20 is?
Yeah, I caught that as well. That should be 330A:20. And again, that list was not something that the Senate amended. It was something that was straight from the House bill. So I think those are, and we, in the Senate, we did authorize the clerk to make such technical corrections as are necessary. And I think any reference that the House made to a repealed statute or a missing statutory reference, when it's clear that 330A:18, 330A:19, and then the next one is 20, and the next one is 21, there should be a 330 in there as well. And it was my intent when I made that motion, and the Senate President accepted it without objection, that those would be taken care of ministerially.
Can I ask you a question on the amended analysis here? What we're looking at, and the biggest change here is the addition of the word "to propose." The House version basically, addressed the engage aspect of this and not the "to propose." And I'm wondering how you envision this unfolding. Let me see if I can give you an example. If you're a professional counselor as identified in the proposed legislation, and if a parent comes to you with an 8-year-old or a 9-year-old who is, let's use the term, confused about their sexuality, or has made a statement, does the parent potentially going to run into an issue as to receiving counseling here? Is the therapist with the word "to propose" going to be very cautious about even discussing these issues of sexuality or perhaps sexuality?
That is, if I may respond, that was something that was brought up in the Senate and which was discussed. And again, if you look at the definition of conversion therapy is defined as referring to any practices or treatments that seek to change an individual's sexual orientation. So if a licensee speaks to a child about that child's questioning about their sexuality or about sexual matters generally, that does not fall within the definition of practices or treatments to seek to change an individual's sexual orientation or gender identity. Now, if the counselor goes a step further and does engage in what that field of, I don't want to say science, but if in that field considers to be appropriate treatments to change sexual orientation, only then would that licensee be coming up against this prohibition.
Yeah.
But merely speaking to a child about sexuality would not run afoul of the definition.
If I could just follow up on that, and it just seems to me, and this is where I'm trying to draw the line in my own mind, if that scenario we just described, if the counselor, for whatever reason, makes a decision to the parent concerning the child that says, you know, I think little Johnny or little Mary is somewhat confused. I'd like to continue treatment, or maybe treatment isn't even the word, basically saying I have doubts that the child is really gay, then how do you draw the line here of stepping over that line into conversion therapy and whatever without infringing on the right of the therapist? It just seems really kind of a grayish area, and I'm a little concerned about it.
If I may ask, which rights of the therapist are you referring to?
It could be any of the licensed therapists that were described in the proposed legislation, psychologists, psychiatrists, whatever. Basically, the issue, Senator, would be if, let's say, an initial consultation, let's say I'm the parent, and my child comes home, maybe through an influence in school, and says, hey, Dad, I'm gay. And which is fine. And if the parent then chooses to say, geez, is she or isn't she? And if I go to a licensed therapist and the therapist concurs that the child is not gay and then may schedule another session, are they now in danger of running into what we might be passing here? That's my, where do we draw that kind of nebulous line here?
Right. Again, I think you have to refer back to the plain words and the plain meaning of the words in the definition of conversion therapy that both the House and the Senate passed. And if they're engaging in practices or treatments that seek to change that sexual orientation, then they're engaging in conversion therapy. If they're speaking with the child about the child's questioning about whether they're gay or straight, that does not run afoul of that does not amount to a practice or treatment seeking to change. It's elucidating, it's clarifying. I mean, on the first time this came up, because the Senate debated this in one session and then special ordered it to the next week. And in order to build a record, in my floor speech, I said, this is what the bill does, and that's what I was just referring to. But there are a number of things that this bill does not do, and it does not run afoul of something like that. It does not run afoul of a parent talking to a child. It does not run afoul. I even gave an extreme example, is that if a licensee believes in conversion therapy, and conversion therapy is in that licensed therapist's mind is a legitimate science, there's nothing in this bill that would prevent that licensee from referring that minor to someone who does practice conversion therapy. All the bill does is prohibit that licensee from himself engaging in conversion therapy. Now, I would hope that the licensee, knowing the statistics of suicide of those LGBT teens who have undergone conversion therapy, would not make such a referral because the science is not on the side of that as being a viable alternative. But the bill would not prohibit even that.
Thank you, Senator, for that. Let me follow up on that because now I'm really confused. If we identify under the RSAs all of those licensed therapists who would not be able to engage in conversion therapy. Could you explain to me how a referral would work? I mean, you either can do it or you can't do it in New Hampshire. Am I missing something? Are you saying a referral out of state? Or?
No, non-licensees can engage in conversion therapy because we can only regulate, and the bill only seeks to regulate licensees. So if a licensee makes a referral to a non-licensee who engages in conversion therapy, that would not run afoul of this bill. It prohibits the licensee from actually engaging in the practice of conversion therapy. This says nothing about prohibiting referrals to. I would like to see that, but it doesn't say that.
Okay, I missed that, frankly. So an unlicensed, I hate to use the word professional, can engage legally in New Hampshire in conversion therapy?
Well, this bill only prohibits licensees from engaging in conversion therapy. So if you're not a licensee, you're not subject to the bill.
And clearly, I also, if I could just follow up one more time, I saw at the end that any religious conviction or belief would also be exempt under this.
Well, the Senate, specifically the House, which did not come over with any reference to religious freedom, the Senate added 332L3, saying nothing in this chapter shall be construed to infringe on any constitutional right, including the free exercise of religion. So if a licensee believes that he or she has the free exercise right to engage in conversion therapy, they may have that claim. But I will point the committee to when New Jersey passed this law, it was challenged in court in the case of King versus New Jersey and Prescott versus Brown. Both analyzed the free exercise claim under the 1990 U.S. Supreme Court case on Employment Division versus Schmidt, which says that a law that applies generally and does not target religion specifically must be complied with, and no one can claim a religious exemption from it. It was Justice Scalia who was writing for the court. In that case, what it was the state of Oregon had banned the use of the hallucinogenic drug peyote. And two members of the Native American Church in Oregon said that the use of peyote was central to their religious ritual. They therefore claimed a free exercise exemption to the general prohibition. And Justice Scalia wrote that that a law that applies generally and doesn't target religion specifically cannot be disobeyed by claiming a free exercise right. That's why, in fact, I have the case here if you'd like to read it. But it says Oregon's ban on the possession of peyote is not a law specifically aimed at a physical act engaged in for a religious reason. Rather, it is a law that applies to everyone who might possess peyote for whatever reason. It is a neutral law of general applicability. Justice Scalia characterized the employee's argument as an attempt to use their religious motivation to use peyote in order to place themselves beyond the reach of Oregon's neutral ban on possession of peyote. And he wrote, quote, "To prevent this would be to make the professed doctrines of religious belief superior to the law of the land, and in fact to permit every citizen to become a law unto himself," end quote. And so that's why the U.S. Supreme Court has upheld laws against free exercise challenges. Those laws forbidding polygamy, child labor laws, Sunday closing laws, laws requiring citizens to register for selective services, and laws requiring payment of Social Security taxes. So the free exercise claim is defined as defined by the U.S. Supreme Court, and specifically the opinion written by Justice Scalia says that if the law is not aimed at religion, that applies to everyone covered by it, without regard to religious practice, then a religious exemption could not be claimed, because that would essentially nullify the law itself, because anyone could say, I have a religious objection to it, whether they do or not, and undo the law.
President MacKay, you had a question?
Thank you, Mr. Chairman. I'd just like to comment on 332L2 and 3, which I believe strongly don't change the House position at all. The first one, and I used to sit on the licensing board for Mohawk practice, which licenses 5 different groups. And what this says is that and shall be subject to such discipline as the relative licensing authority deems appropriate. That just clarifies what has always been in place. That's what licensing boards do, so that just states it clearly. And I think it adds to the legislation so that there's no confusion. But having served on those boards, I'd say that they are extremely cautious about how they proceed and very careful and have attorneys on all sides. So I could very easily see that to the Senate. The second one essentially says nothing in this chapter shall be construed to infringe on any constitutional rights, including the free exercise of religion. All that says is that we're following the Constitution in this legislation. And the House, of course, already did that. This just makes that very clear. On the third question, which is the one that's more troubling, is nowadays the categories have changed over times, but now it's lesbian, gay, bisexual, transsexual, and questioning. And I think part of what is concerning people is those who are questioning themselves as to who they are. That's a legitimate therapeutic responsibility. The therapist takes no position about what's right or wrong for the individual, but helps the person to clarify who they are, what their position is. So I don't think this does anything more than it brings clarity to the House position. And so I'm prepared to cede to the House, to cede to the Senate, but I'm just one person.
Sure, Senator.
And based upon what Senator Pierce had just told us, since the Senate amendment is not focused on religion, but focused on a professional group, what I heard you say was that since it was focused on that and not religion, that basically religion would not play a part in any of this. So that if you had someone who was a minister licensed, that he would not be able to bring his religion into this. Which, I mean, what I heard seemed very contrary to what was told to us on the Senate floor.
No, what was said on the Senate floor is that the non-infringement provision preserves the free exercise claims of any licensee as the Supreme Court has defined the scope and extent of the free exercise clause. That's what was said.
Okay, so if this law is passed, can a nurse talk to her own children about gender issues, or is there an exemption for licensed parents talking to their own children? And if so, where is that in the bill?
The non-infringement provision from the Senate version says not intending to affect any constitutional right, and both the U.S. and New Hampshire Supreme Courts have ruled that parents have a fundamental constitutional right to raise their children and to control the health, education, and welfare of their children. So again, that would fall within whatever rights they have constitutionally would not be infringed by this.
Do constitutional rights, free speech extend to all licensed professionals?
Well, yes, every person has free speech rights, but whether the speech in Representative MacKay may be able to speak to this more astutely as a mental health counselor, but every licensee has free speech rights. But if they say something that constitutes malpractice, and I think I gave on the Senate floor the example of if there's a deeply depressed person and the licensee says you need to go get drunk and stand on the roof of your house, clearly he has the right under the First Amendment to say those words, but whether it constitutes malpractice under the license is a separate issue.
Before we go any further, I think I'd like to hear from the department if you had expressed some concern. And I'm awful with names, you should
That's okay.
identify yourself.
Can I speak from here? Is that all right?
Why don't you come up here and have a seat? You're like we'll put the spotlight on you.
That's fine. I'm good with that. This looks like a reasonably safe group today. Good morning. Thank you for your time. My name is Tricia Lucas, and I'm here as a representative of the Department of Health and Human Services. And we have a very, very limited role or discussion point for this committee of conference. We did not take a substantive position on this bill either in the House or in the Senate. What we did raise in the House is provisions in the House bill which are on, I will tell you in just a minute, are on page 4 of the bill as passed by the House. And I'm sorry, I do not have a lined copy, I apologize. They are Roman 2 under the new chapter 332L, which is the definition of department.
You hold on one second.
Yep, I certainly
Make it
can.
by the House.
As passed by the House.
All right.
I am on my page 4. I'm sorry, I probably have a lined copy somewhere, but I don't have it.
Yeah, I don't have a line copy either.
Okay, then if we're on page 4, this is the section of the new chapter 332L, and it's in the first section is in the definition section. There is a definition of department, which is Roman 2, and then there is under 332L section 2, which is prohibitions, violation, and enforcement, there is a Roman 3, which confers concurrent enforcement jurisdiction on the Department of Health and Human Services. And we had spoken to this in the House when we testified in the House, but we didn't get it raised in time. We thought that the bill might be subcommitteed, and it was not. So we were not able to address the request this concurrent enforcement provision be removed. We raised it in the Senate, and as part of the Senate bill, it was taken out. Our concern with concurrent jurisdiction in the department is that we have no direct involvement with the licensing boards. In legislation that you all passed a number of years ago, you created a separate entity to oversee the licensing board. So they are no longer administratively attached or connected in any way to the department. We have no specific expertise with the issues raised, presented by this bill, and no enforcement authority to involve ourselves. So for that reason, we had asked that those particular sections in the House bill be removed. Obviously, the Senate took a different approach to the legislation. So by definition, these provisions did come out in the Senate version. So my job here, in an effort to confuse further the issues that you already have to deal with, is to say, regardless of what you do, if you pass something, please don't allow the don't give the department concurrent enforcement jurisdiction.
Yeah. Sure. You mentioned sections.
Yes.
Is it just, you pointed out one section.
It would be, if you were working off the Senate draft, Senator Prescott, you would be deleting 332L, Roman 1, Roman number 2, and 332L 2, Roman number 3. Did I get that right? I
Yes.
look like I
Yes,
confused
you
it.
did.
I actually have copies of the House
So there's no
version
need
of
for
the
a
bill
definition of the department, and then no need to,
to give the department
Authority.
jurisdiction. Right. I do have marked copies, at least several, and that would be helpful to anybody.
thank you, Commissioner.
Thank you.
Okay, thank you.
Thank you very much for this, Mr. Smith. Thank you for letting me interrupt your discussion.
Okay. Any other questions here?
I have a question as to the confidentiality. My understanding was a doctor-patient confidentiality is covered under HIPAA. So, you know, we're talking about a lot of things that become known. How do they become known if they're covered confidentially under HIPAA?
Go ahead.
If I may, Mr. Chairman.
Sure.
Could you clarify, like, what would become,
So we talked a lot about that somebody might violate what we're proposing here,
right?
but how do you know about that if it's confidentially covered under HIPAA?
Well, the licensee, of course, is the one bound by HIPAA and would be the one prohibited from making it public or otherwise disclosing it. But the patient is not bound by HIPAA because that information belongs to the patient. And so if the patient wants to reveal that, that's up to him or her.
I have,
Yes, Senator Prescott.
you were attempting to speak, if that's all right with me.
That would be known if a particular patient complained, or say one of the parents found out that the other parent took the child, they could complain to the licensing board.
Any other questions? Okay, what we have before us is a,
Sure. Representative MacKay, I brought attention to that line after discipline, as the relevant licensing authority deems appropriate. You were comfortable with that, you served on the licensing board. What 5 jurisdictions were there?
Social workers, pastoral counselors, mental health counselors, marriage and family, and when I was on psychologists, they now have a separate board. So it constitutes the largest population of people who are in that field. And you get nurse practitioners, separate board, psychiatrists, separate board. I think that, from my point of view, this clearly states what licensing board is supposed to do. I don't think it's ambiguous at all.
So you don't believe a rules process is necessary
I don't.
to bring stricter direction?
I don't, but occasionally they do rulemaking. I used to sit on job
Yeah, it is.
but I don't think anything in this legislation requires rulemaking.
senators, any other statements, concerns? You want to voice it this time?
Well, good.
Do we want to change these technical parts, or do you want to leave it up to the enrolled bills? And I'm the chair of the enrolled bills, and I'm okay with what's been described so far, but I'd hate to see something that I could say no to if we don't give it a real critical eye for anything we can find now.
I don't see anything there, but, you know, there's no such thing as a perfect legislation. But I haven't seen things that just jump out at you.
And what errors are here are technical, for sure.
Senator Kotowski, you had your hand waving.
I'm conflicted by all of this, quite honestly. This bill went through our committee. It came out of committee overwhelmingly, went to the House floor, was debated exhaustively. Came out of the House, went to the Senate. I would have thought the House version would be the version that I could vote for. I would have thought that. Until today. Today I see the bill comes in. There's been some work done in the Senate that appears to have resolved some things. In my mind, I'm concerned because I think we're going to be back here next spring, next year, addressing this bill to correct the things that aren't right now. I'm not prepared personally to move off of what was in the House bill.
Representative.
To my mind, the reason I can support this is I don't think it goes off of the House bill at all. It just clarifies some key areas. And so I feel it didn't change the House bill at all, it just makes it clearer.
Senators, any comments? We've heard. Sure, Senator.
Thank you. I think the Senate version did correct some of the things and put in some protections that the House bill did not, but I think in the amendment that we passed at 9 o'clock at night, that it also raised some other questions. On line 28, when you talk about any licensed professional who proposes to engage, I'm not really sure what that means. If I were a licensed professional and I were to say, this person needs conversion therapy, and somebody overheard me, could I now be disciplined because I was proposing that they engage in conversion therapy? I'm concerned because I've been around the legislature for 20 years now, and I keep hearing about how government should not intervene between a doctor and a patient, and yet here's something that I see that is more egregious than anything that I have seen in my 20 years here, that the government is coming in and telling licensed therapists or professionals what they can say and what they can't say under discipline. I disagree that they are somehow exempt from the free speech. I think that constitutional right of free speech should go into the profession for which they were licensed, and they should be able to give their own personal evaluation of what's necessary to help that patient out. By what we have in the Senate, we're saying, no, you can't do that. It has to be one-sided. You can't suggest for somebody that you try to lead them to heterosexuality. I don't think there's provisions in there that will protect parents or grandparents who may be licensed from trying to help family members. I think these are all open to interpretation, and I don't think that good legislation, particularly in something like this, should be that open. I would have a hard time accepting this. As I said, I do agree that there are some things that have been closed up with the Senate version. I appreciate that the 5.5 pages of scientific stuff has been taken out in the Senate version, but I don't see the thing ready for prime time. I think it still has a lot of open questions that, as a legislature, we can't afford to let go forward as a trial experiment. And I think DHHS has already said that this conversion therapy, and we don't even know if it exists in New Hampshire. That question was asked on the Senate floor too, and nobody could give an answer. But even DHHS considers it as experimental therapy. So at this point in time, I would have a hard time going forward with it as well.
Representative Gordon, any question?
Yes, it's my understanding that if a parent or a grandparent, as you stated, is a licensed professional and offers some type of counseling or dialogue with the grandchild, that you're concerned about this. But it is my understanding that if you are a professional and are charging for that service, you would then be held liable under the boards. If a grandparent is going to sit and talk to a grandchild and charge him, that may be an issue, but if it's a conversation in a home, I can understand why that would be a concern to you, based on how.
Question?
Yes.
Where in the Senate version do you see anything about being paid?
Well, my assumption, and maybe it's an assumption, is that you are acting in professional capacity, then you are in that professional relationship, which includes a payment. You are seeing a doctor, you're assuming that you're paying for that. You're seeing them in a professional capacity.
Paul?
Sure.
If I were to go to my pastor for counseling, would you expect that I would be paying that?
If you're seeing your pastor because no, I would say no.
So
That is allowed.
that kind of breaks the mold that you were just talking about, though. So not everybody gets paid for counseling. And again, I'm not.
But this bill has made allowances for pastoral counseling and senior counselor, seeing your clergyman. So I don't see a problem with that.
Representative MacKay?
Thank you, Mr. Chairman. A lot of the questions that you're posing would come under the fact that every professional person, a healthcare provider, operates under an ethical system. When I was first licensed, you could hang it on the wall. It's about this thick now. There are every kind of condition you can think of that you have to comply with. And for example, can a licensed person talk to their children? Of course, because the licensed person could never be the therapist for those children. That would be unethical practice. So that for every one of those professional groups, including physicians, nurses, and all the other mental health professionals, they operate under very severe ethical constraints. And that's part of what the licensing boards deal with. So there's very little statute that they deal with. It's much more the ethical principles that they subscribe to. And so that wouldn't show up in statute at all. But you can easily go to these professional groups and see the significance and impact of the ethical prescriptions.
If I could sum this up, as time is going on, at this point, we have a couple of options in front of us. The Senate can accede to the House position. We in the House can accede to the Senate position. Or we can come to some agreement in between. So what I'd like to do at the moment is ask you to caucus among yourselves. Let's get a sense of where we are on this, if there's any movement, and then we will make a decision one way or the other. Is that agreeable to the Senate members? Okay, let's take a 10-minute recess and accomplish that. When we adjourned, the House members met, and I presume the Senate members have met. So let me present to you the outcome of that caucus. On the House side, and certainly not unanimously, but we have a member here who is only prepared to fully support the House position on the bill. So what that means is the Senate then has an option. They can accede fully to the House position or not. But frankly, under the Committee of Conference rules, it takes a unanimous vote, and we don't have it. So with that, I will defer to the Senate.
The Senate doesn't have the votes to accede to the House position. And I doubt you get any votes. No vote was taken on the House bill as amended by the House. It was agreed upon that that we would have as many amendments come forward on the Senate floor as members of the Senate wanted to bring forward. No person in the Senate brought forward the House position. There's 0 votes in the Senate for the House position. Therefore, I am obligated, as well as my own personal opinion, do not want to accede to the House version. I think we did yeoman's work in the Senate. I would agree that if we have conflict somewhere in the language, that we would work with that. And that is the Senate's position about acceding to the House.
I normally accommodate, but are you a member of the?
I am a member. I have replaced Representative
Okay,
MacKay, who had to go to a meeting.
okay, please.
So I am just going to ask for the record, there is no functional difference between the House position and the Senate position, and I would very much like to be able to accede to the Senate position, which I think clarifies some issues that have concerned people. And I wonder if any consideration has been given the House position was more than 2 to 1 in favor of this bill, to replacing the member who will not accede to the Senate position with somebody else who might be willing to accede to the Senate position.
My understanding is one of the original members that had been appointed has been replaced. So now we have the second member. The second member is fully supportive of the House position, which is, frankly, it leaves, my understanding, leaves no room for replacement, because he's doing exactly what he is, what has occurred in this committee and on the House floor. So the answer to your question would be no.
Thank you very much for the answer.
Mr. Chairman, may I ask, what are the, are we allowed to know who this member is? And I'd like to know, what is it about the Senate version to it that he objects to? And can we work through it?
My somewhat understanding is, you know, I'm not even sure I'm fully prepared to answer that question. I know he was troubled by the words "to propose," which were put in. Unfortunately, he's not here at the moment to fully explain it. But Senator, I don't know what else I can say to you. It's just, you know, he was adamant, so he wants the House position, and you guys want the Senate position, and it's not going to come together. So.
Well, it can if we can discuss it, or could, at least opens an avenue to doing that if we can discuss it.
I guess at the moment here, I mean, looking forward, if you choose to accede to the House position, then I guess it would move forward. But you just heard differently.
Oh, I think it seems a bit obstructive to say we're going to, that this particular individual is in favor of these provisions but not these, but is, we're not allowed to know what those positions are.
But again, again, I'm not here to defend him, but I would tell you that it's certainly within his prerogative to fully support the House position.
Oh yeah, that's not an issue.
Yeah.
The issue is that if he supports the House issue, the House position, and maybe he's able to persuade the rest of us that he's not here to do it, nor do we know what it is about the Senate version that he does not like. What is it that the Senate version does to the House version that he feels like he needs to support the House version alone? I mean, I'm not sure we can come to a conclusion unless we have all the information.
Yeah, apparently not. But at this point in time, I don't know what else I can say other than to, you know, the votes have been taken. You know, I have no other option, frankly, but to close the meeting.
We could recess it until we can try to determine what it is we're talking about. I mean, I don't understand why we can't talk about it.
Is that the position of all of you senators?
Yes.
I took the time over our break time to read through some of the other information we were giving, as well as going back and rereading things. And number one, I have a problem with the House position because I feel that there are a lot of protections that did not exist there that existed in the Senate. But then we get a communication also from legislative Scott Eaton. It just seems though we are trying to fast track this thing. His communication to us is that it's almost impossible to have everything in place by the time that is required by these things. I mentioned before that I have a number of things that I'm not comfortable with, and maybe I'm misunderstanding them, or maybe I'm not. But I think clarity needs to be brought into it. And I don't feel that we have the time between now and Thursday, where, I mean, most of us are on multiple committees of conference, and I don't feel that we really have the time to go through and to fix this to the point that it is clear as to what people can do, what they can't do, when somebody's license is in jeopardy, when it's not. That's what happens when you bring in something at 9 o'clock at night. And I think probably the best thing to do is just to not exceed. And if people want to work on this over the summer, then take the information that has come out of this committee of conference, that have come out of the House and the Senate sessions, and put together something that is not questionable in people's minds, because I feel the citizens need to understand this if we're going to go forward and do that, and that we're not anywhere near that position right now.
Representative Weather.
I just want to say that I think it's particularly unfortunate, given that this is a committee of conference and we're supposed to be discussing something, that the person who is unwilling to move forward with it has absented himself and therefore is not available for any kind of discussion. What I'm hearing from the senators is that they are no longer willing even to defend their own position in the matter, and if that is true, then I certainly concur. There's no point in spending more time on it, but I think it's unfortunate on both sides.
Let me clarify the Senate position. In the Senate, we do not have a hard, fast rule of negotiating only for the Senate side. There may be difference of opinion in the House than it would be in the Senate. Senator Daniels has said, I'm willing to look at any language, and we've discussed language in our meeting, and we're moving towards a piece of legislation I think we need to move towards. And if it can be done, the Senate will do that. I can assure you of that. And I do not appreciate a member being missing who is the only one involved with the ending of this committee of conference. And I think it's very inappropriate that it could happen. I hope it doesn't happen. I think that we should meet again at a time convenient, and today is the right time. We should continue. We should find where the representative is, and we should bring him forward so we can understand what is the concern, and maybe there is a way to rectify that. Otherwise, this is not fulfilling the obligation of the House and the Senate to vet out any ideas. I believe it's premature, and I would ask that we would wait until a recess. We wait until that person is available at a certain time, and we meet again and hear them out.
Well, thank you for your comment. What I'm going to do is I'm not going to recess. I have no sense that there's any give here at all. And it's just not going to happen before Thursday. I just think it's physically impossible. My apologies to all of you who would disagree with that decision, but frankly, at this point, I'm just trying to move this forward. I have no sense whatsoever of flexibility here. I don't believe it's going to happen. And I think I'm just being pragmatic and being realistic of what's really capable of occurring.
And your apologies to the children who will go through conversion therapy.
Excuse me.
You're out of line.
I am indeed.
You certainly are. And I think there was no testimony, frankly, to answer your question, that this was a great problem in New Hampshire to begin with.
Any problem.
That's as far as I'm going to say on that.
May I say that it is not the Senate's position that this should end. We are more than willing for the next 3 days to work on this situation. And if there is a reason to stop it, it's not the Senate's position whatsoever, without any confusion in that matter, I assure you. The Senate wrestled with this for, I would say, 3 months, 2 months. It has been on the Senate's mind. People made their decisions late because they wanted to be certain that they were doing the right things. This is not something that the Senate has been taking lightly or hoping it would die in a committee of conference. The Senate's position, 16-8, is to pass the prohibition on conversion therapy on minors. This is, partly you can view this as just a prohibition on a licensed individual. It is what a licensee cannot do and what a licensee can do, and there's discipline by a licensing board expressed by Representative MacKay that is completely appropriate. As I mentioned earlier, I said, if there is more clarity needing to be made on lines 28 of the first page about any licensed professional as listed in paragraph 1 who proposes to engage or engages in conversion therapy, and then lastly, as the relevant licensing authority deems appropriate for those disciplines, let's make it clear. Let's take the time to do that. I cannot do that without understanding what the objections are of the House. This is completely inappropriate to not even state the case of why we would not continue to meet and discuss, and where is our impasse. We don't know if it's the language of concerning proposing or engaging in this practice. We don't know if it's the language of the discipline would be conducted by the relevant licensing authority, what they deem as appropriate. We do not know that. We don't even know if it's a line part of the definition of conversion therapy. These things need to be discussed, or else we are making no progress after right now. If the ultimate end is that we do not come to an agreement, at least we'll know where the sticking points are so that we can proceed in a solid fashion coming up for next legislation series. And I do not want to stop talking. I would rather that someone find this representative and get it over here.
Senator, for the very reasons you mentioned and all of the things that surfaced during a very prolonged debate we had on this subject starting at 9 a.m. basically reinforces to me why this is not going to be resolved by noon on Thursday. For the very reasons you mentioned, it's probably worth going forward for those who wrote the bill to come back with another bill that maybe addresses some of these concerns. But what I do know is we're not going to resolve it today. I don't see this going forward. I understand your disappointment, but frankly, what I'm going to do now is someone had to hand up and hear it, and then I'm going to adjourn the meeting because I think we're at an impasse. So we've heard it. Representative Gordon?
Yes, unlike the good representative, I believe that I can speak and say that we have, if this process ends this way, we have done a tremendous disservice to a lot of people in the state that look to us to protect them. And I believe that that process is just, it's not ended the right way, and I feel very disappointed that we haven't been able to do it, and there is a disservice that's been done.
Thank you for your comment.
And Mr. Chairman?
Yes, Ms. Senator.
Also, you know, you speak in terms of bringing a bill next time in order to address the concerns, but the point is, we don't know what the concerns are. How can something be addressed that cannot be spoken about? Now, the differences between the House and the Senate versions are, the Senate version takes out the purpose section. If that's his objection, we can talk about that. The Senate version takes out, or the Senate version adopts the House definition of conversion therapy. The Senate version adopts the Roman II about the discipline. The Senate version adds protection for constitutional rights that the House version did not have. So are we to assume then that the objection is to adding religious protection? Because again, if the House version is the only version that the member will vote for, then that means that, I guess it's safe to assume that he objects to adding religious protection to the bill. Because he won't vote for it. And again, the point of bringing a bill in order to address concerns is we need to know what the concerns are. And cutting off debate in order to make sure that we don't know what the concerns are does the disservice, and I think brings disrepute to both chambers if we can't even talk about it.
Well, let me just say this. And again, we could debate this going on, indefinitely. But what we've heard here are two positions taken from the Senate side that they can't support the House side. On the House side, and again, under the rules, it has to be unanimous, that they could only support the House version. I guess I could keep this hearing open for another 2 hours, but I'm not sure that that's going to accomplish anything. And so with that, I'm going to close this hearing and report out as we have discussed. So I thank you for your attendance. I thank you for your participation. But this meeting is adjourned.
Yes, I am.
Letter to letter discussion. Disagreements.
Who are you looking for? Oh, he should be, that's what I'm saying, let's go. He should be here any second. He'll be here.
Yeah, right. I know you did. I'm gonna listen.
He'll be here. You want me to find him?
No, that's fine, he's coming. He's on this committee.
No, I know, he's, what time is it? Oh, yeah, he's got 4 minutes. He's got 4 minutes, that's how he works. This one right here. There he is. See, told you.
4 minutes.
He's got 3 minutes to spare.